Are we on the record? Okay. Good morning, everyone. I would like to call to order the City of West Palm Beach Special Magistrate Code Enforcement Agenda for July 6th, 2022. My name is Keith Davis. I'm the Special Magistrate appointed by the City to preside over today's agenda. As we get started, if you'll please silence any cell phones or any other noisemakers that you might have so they don't interrupt our proceedings, that will be appreciated. If you're going to be speaking to me about any of the matters on our agenda, your testimony needs to be under oath, so I need to swear everybody in who's going to be testifying. If you are going to be testifying, please stand, raise your right hands. And do each of you swear or affirm under penalties of perjury today that your testimony will be the truth, the whole truth, and nothing but the truth? Thank you. You can all have a seat. I believe we have a sign-up sheet. The way we will proceed today is we'll be calling the cases on the sign-up sheet first, as well as there may be some cases where there are city personnel that are required to testify that need to get on with their day. So we'll be calling those cases first. When your case is called, please come up to the podium to my right. Over here, the city will be presenting from the podium to my left. There will be testimony, there may be photographs or other documents which will appear on the monitors. You'll have an opportunity to see those documents, hear the city's testimony. Once the city's concluded its presentation and made any recommendations for how the case should be resolved, I will then hear from you. You can tell me everything that you feel is important about the case. If you have additional documents or any additional photographs that you want me to consider, that will be the time to produce those. Once I've heard everything from everybody on the case, in all likelihood today, I will enter an order that resolves the matter in some form or fashion. So generally, that's how we'll proceed. Let's go ahead and get started with the first case this morning.
First case number 2726 19th Street, CE 22050271, number 2726 19th Street.
Good morning.
Good morning.
My name is Ryan Brown, Inspector 9767. The address of the violation is 726 19th Street, code case CE 22050271. The notice of violation was issued on 5/23/22. The notice of violation was mailed via certified mail and regular mail on 6/16/22. And it was posted on the property and at City Hall on 6/17/22. It was delivered and left with an individual at the address on 6/25/22. I personally witnessed and photographed the meter, the absence of the meter, and cited it for no water. We recommend, the city recommends they obtain a meter within 10 days or $50 a day.
So there's no meter at all?
Correct.
And there's no water running to the property?
That is correct.
Okay. Is there anybody here on behalf of the respondent for this case? Okay. Ms. Frankenauer, did you need to elicit any additional testimony? Go
Yes,
ahead. Sorry.
just briefly. Thank you.
Thanks. Go ahead.
Mr. Brown, is there a completed affidavit of posting in your file? Is that what actually is the affidavit that we're seeing on the screen? Is
Yes.
that consistent with something that you completed previously?
Yes.
Okay. And with respect to, there's a red tag that we saw. Did you post that red tag?
Yes.
And that was consistent with what you're testifying here today for?
Yeah, there should be a picture of that red tag posted on the property,
Okay.
which was removed
Okay.
when I re-inspected.
All right. And the photos that we quickly reviewed, those are the photos of the property in question today. Is that accurate? Okay.
Yeah, if they match the ones that are in my folder.
Okay. Well, you did testify to posting. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and red tag.
Thank you. Those documents are all part of the record, and the city has proper notice, even though the respondent is not present. Is this an occupied?
It's definitely occupied, sir.
Okay. So your recommendation is to give them 10 days to get a meter installed and water flowing to the residents, and failing that, what was the,
Or $50 a day. That's correct, sir.
all right, thank you. Is there anything else on this one?
No, sir.
Based on the testimony and the evidence, I do find the property remains in violation as cited. I will accept the city's recommendation, require compliance within 10 days, meaning the installation of a meter, and I suppose that requires the opening of an account.
That is correct.
And failing that, then there will be daily fines of $50 per day until compliance is achieved.
Thank you, sir.
Thank you.
Next case, number 275601 Hobart Avenue, CE 22060168, number 275601 Hobart Avenue.
Good morning.
Good morning. Richard Pazmino, City of West Palm Beach, Code Enforcement.
I'm Ed Garcia. I'm the owner of the property.
This property was cited on June 14th. Certified mail was sent out June 17th. Sign received June 21st. In addition, the property and City Hall were both posted on June 21st. This case is a repeat violation of case CE 200800329 for prohibited vehicle being stored on the property. I first observed the violation on the 13th of June. I spoke to the owner on the 22nd, and I performed the reinspection on the 23rd. So this case was 10 days out of violation, and the city's recommending $100 a day since it's a repeat violation. So that's a $1,000 fine.
Officer Pazmino, do you have a completed affidavit of posting in your file?
Yes.
And with respect to the underlying order that you talked about, do you have information as to when that order came into compliance?
The original case,
Correct.
I don't have it on me on this.
Did we find that one?
It was an adjudicated case back in 2020.
It was or was not?
It was.
It was.
Yes.
So we'll find that in
Yeah,
a second.
That's the
Okay, so
in
this is
effect.
we're viewing the underlying case order of CE 20080329. I'm sorry, my
Yes.
vision isn't great this morning for some reason. And the date of that order, can you scroll down?
October 7th,
Thank you.
2020.
Okay, thank you. And then, again, do we have a affidavit of compliance? And in the meantime, Officer Pazmino, can you describe your observations of what it is you believe supports that alleged violation?
Yes, the tenants of the property are parking that box truck commercial vehicle. It's being parked and stored at that residence. This is the third case in 2 years, except for the same violation. It would be on the original case.
Special Magistrate, I'm sorry, I just want to establish the compliance with the underlying order.
While you're looking that up, is there any, other than getting the compliance date for the 2020 case, was there anything else before I hear from the respondent?
Yes, Officer Pazmino, photos that are in the file, are those consistent with your observations of the alleged violation on the property?
Yes, they are.
All right. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, on this case, certified mailing documents on this case, affidavit of posting on this case, photographs on this case, as well as a copy of the order on the underlying case, the affidavit of compliance on the underlying case. Thank you.
All right, thank you. Those documents are part of the record for this matter. Good morning, sir. If you
Good
could
morning.
tell me your name and address, and then you can tell me about the case.
Well, I don't live at the property, I'm the owner of it. I live out in the Keys, so it took me a good 3.5 hours to get here today. I'm not disputing the fact.
Yeah, and but let me, for the record, if you can put your name and address on the,
My name is Heriberto Garcia.
thank you, sir. And you are the owner of the property.
I'm the owner of
And I
yeah,
understand you don't
5601
live there.
Hobart.
Yep.
Yes, yes. I did call Mr. Pasnick the very minute that I got the letter. I never got any certified letter in response. I guess that he did mail it on the 14th. I did speak to him on the 22nd as soon as I got notification of it. I did call the tenants immediately to let them know what was going on. They told me the truck had been left there for 2 days because one of his employees just left it there. The owner was out of town. I mean, it's hard for me to control something that I'm really not there, and I'm not disputing the fact that they have done it, but definitely not for 10 days. It is not. I'm retired. I'm on Social Security. I live off $975 a month plus the rent, so it's hard for me to deal with this. On the other hand, if I get rid of the tenants who pay me on time, then I'm on a financial situation myself. They've been notified, though. It can't happen again. And I did contact a lawyer already in reference to this, because they pay me on time and they have a small kid. They told me it's going to be hard to evict them, that I have to deal with this at this level.
Okay.
Special Magistrate, just for the record, you see on the screen the affidavit of compliance in the underlying case of October 15th, 2020. And can we inquire if the respondent has any objection to the documents submitted?
Okay. So the city has
I know
produced,
this, pardon, I'm sorry.
I'll say the city has produced a document that's on the screen now. It's called an affidavit of compliance, which shows that the 2020 case came into compliance on October 15th. Do you have any objection to this also being made part of the record in this case?
No, I believe that I contacted them and it was taken care of right away.
Okay, then the affidavit of compliance from the 2020 case is also part of the record. Mr. Pesmino, how many, is this still in repeat violation today, or how many days?
No, I stopped it as of the 23rd. I spoke to the owner on the 22nd, I think the day after I posted. And then I couldn't go out till the following day, so on the 23rd is when I saw it.
How many days did you, was it?
10 days
10
out of
days?
violation.
And the city's asking for $100 per day for each of those 10 days that it was
Yes.
in repeat violation. What was, can we go back to the order finding violation on the 2020 case? I wanted to see what the, how that case was handled.
Yeah, I was given 7 days, and then they complied in that 7 days.
So no fine was ever assessed on that case?
No,
What was the, had it not come into compliance? Do you know what?
can't remember.
Yeah. There we go.
No.
You scroll down a little bit more.
$100.
That one was $100 per day as well. Okay.
And this is the third case. I think I cited it last year, but I didn't cite it for repeat.
Okay.
But it
there any
was,
fines assessed as a result of that, or did it?
no, they complied before.
Okay.
Yeah, that second time, they had actually stopped for lunch at the house. I explained that to you.
It can't be parked or stored in the
Well, no,
neighborhood.
but you cannot even make a delivery or nothing. You can't stop the truck. I mean, that's
They know that,
it's
and
tough.
you know
yeah.
that.
No, I understand. And they, they know. But I'm the one being left to deal with.
Okay. Anything else from the city?
No.
Anything else?
No, no.
Okay. All right, well, first of all, the city has proper notice, respondent is present, the city has the appropriate notice documents in the file. Based on the testimony and the evidence, I do find that the property was in violation of City Code 2635. The substantive code violation was 94-487B1 for prohibited vehicles. I find based on the testimony and the evidence that that violation was a repeat violation pursuant to City Code 2635B. I understand everything you're telling me, sir. You know, as a landlord, though, the final responsibility lands with you. If you're an absentee landlord, you have to, you know, it's still your responsibility. And I understand everything you've told me about having tenants that pay on time, but it's not appropriate for them to park that vehicle at that property.
It's not gonna happen again, I can guarantee you that.
Okay. Well, I am going to, here's what I'm gonna do. I am going to give you the benefit of the doubt. I'm going to oppose daily fines of $50 a day for the 10 days. But I will tell you, if I see this again, I will have no patience and no sympathy, and I will impose probably a bigger fine than the city's requesting. So this can't happen again if you do not want a serious
I understand.
consequence.
Thank
So
you.
I'm giving you the benefit of the doubt today, but it won't happen again, okay? Thank
you.
you very much.
You'll get your order in the mail.
Thank you.
Next case, number 8, 4200 North Terrace Drive, CE 22050250, number 8, 4200 North Terrace Drive. We have a respondent present for 4200 North Terrace Drive. Okay, next case, number 37, 1733 Village Boulevard, number 206, CE 22050128, number 37, 1733 Village Boulevard, number 206.
I need to be sworn in.
Pardon me? Oh, you need to be sworn in?
Yes, sir.
You swear or affirm under penalties of perjury, your testimony today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you.
This property was cited for failure to obtain a rental license and certificate of use. Property on City Hall was posted on 6/21/2022. A license was applied for, and the payment was not made until 7/1. On 6/27/2021, I made contact with the property owner via email with instructions. Nothing was done until 7/1, so the city is requesting 30 days to come into compliance with obtaining the inspection, or $200 a day thereafter.
Inspector Levine, or Officer Levine, excuse me, is there an executed affidavit of posting in your file?
Yes, ma'am.
And the photo that we're seeing, is that an accurate and consistent photograph showing posting on the property in question?
Yes, ma'am.
And Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and the rental license application, and the emails to which Officer Levine testified.
Those documents are part of the record. Did you recommend a 30-day compliance time?
Yes, sir.
Thank you. All right, anything else from the city at this time?
No, sir.
All right, yes, sir. Go ahead and tell me your name and address, and then you can tell me about the case.
Hi, hello, good morning. My name is Jacob Rodriguez. I represented the all units in here. I sent the information for the violation. I sent all documentation. I'm paying the everything permits. Only need to schedule see the all unit and that's it. Only need to tell you what that is. The all unit is tenant occupation. I need call for the tenant for and schedule go to the visit for the inspection.
So if I understand correctly, an application's been made, but you still need an inspection to be passed?
Yes, sir. When I sent out the email to them, I made mention that I was going to be away for the 4th of July weekend, and this case comes before the magistrate on the 6th. Other people had responded and gotten their inspections, but they never responded to get their inspection done. And like I said, the payment wasn't made until July 1st, so there's no way that the inspection could have been done prior to me going on my weekend.
Is there any reason on the city's side of the equation that if assuming the respondent acts in good faith and has good forward progress, that this can't be inspected within the next 30 days?
It could be inspected in the next 30 days, but I wasn't going to leave the case sitting there and not bring it before you today because the inspection, I came back to work today, the payment was not made until 7/1.
Okay, no, I understand. All right, thank you. Is there anything else you'd like to tell me, sir?
No?
Okay. I do find proper notice in this case with the notice documents that are in the file. Respondent's representative is present at the hearing. Based on the testimony and the evidence, I do find the property remains in violation as cited. I'm going to accept the city's recommendation, allow 30 days to comply, so you need to get that inspection done in the next 30 days.
Okay.
And pass it. Failing that, there will be daily fines of $200 per day until compliance is achieved, so you definitely want to make sure you get that taken care of.
Okay,
All right,
perfect.
thank you very much.
Thank you.
Okay.
You're also here for Unit 304, is that correct?
Yeah.
Okay, number 38, 1749 Village Boulevard, number 304, CE 22050129.
Yeah. This property too was cited for failure to obtain a rental license and certificate of use. Property on City Hall was posted on 6/21/2022. There is an active application for a license in the system. However, like the previous case, this application was not paid for until 7/1. Contact was made on 6/27 via email with instructions. So the city again is requesting 30 days to come into compliance or $200 a day thereafter.
So this is in the same posture as the previous?
Same
case?
posture as the previous one.
Thank you. Officer Levine, is there a executed affidavit of posting in your file?
Yes, ma'am.
And Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and application. And if we could inquire a little further this time to just put on the record how this gentleman represents this
you may.
particular respondent.
Yep. Why don't you go ahead and ask?
Okay. Sir, could you state your record for this case?
Yeah, no, I don't have a record in here. For this case, for the all case, you have the inspector. I send all information for email and the payment for the all permit.
Okay, actually, I'm so sorry. So the question right now is, first of all, could you again state your name for the record?
Jacob Rodriguez.
Okay, and again, how are you related to the owner in this case? What is it you
He's
do?
the property manager.
Okay, you're the property manager for this owner.
Yeah.
Okay, very good. Thank you.
Anything else from the city at this point?
Not for me, thank you.
All right, sir, go ahead. You can,
Okay, in this unit is the same problem.
okay.
I just send all information and the payment for the permit. Only need go to the visit for the inspection.
Okay. All right, thank you very much. Then I think my order will be the same in this case as the previous case. Again, I do find proper notice with the notice documents in the file. The respondent's representative is present at the hearing. Based on the evidence in the testimony, I find the property remains in violation as cited. I will allow 30 additional days for compliance to get the inspection taken care of. After that, though, daily fines of $200 per day will be assessed until compliance is achieved. Thank you very much.
And I believe he has two more units, number 40 for 1727 Village Boulevard, number 308, CE 22050132, is that correct?
Okay, this property too was cited for failure to obtain a rental license and certificate of use. The city.
Hang on, just want to make sure I'm on this is agenda item number 40?
Yes.
Yeah, okay, got it. Sorry, go ahead.
This property was cited for failure to obtain a rental license and certificate of use. The property on City Hall was posted on 6/21/2022. There is an active application in the system for a license. However, on last Thursday, when we went to do the inspection, no one answered the door, so the inspection could not have been completed. So the city is requesting 30 days to come in compliance or $200 a day thereafter.
Officer Levine, is there an executed affidavit of posting in your file?
Yes.
Okay. And are there any emails that you had at all with, for this particular case or no?
I think there's an email, but I didn't attach it to the
Okay.
case. But again, when we went to do the inspection, no one answered the door.
Not a problem. Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photograph, and application.
All right, thank you. Those are made part of the record. Let's go back to Respondent. Yes, sir, go ahead. I know you have to keep repeating your name, but for the record, it's a different case, so go ahead and state your name and address
problem.
again. And
My name is Jacob Rodriguez,
yes, sir.
and it's the same case. I just send all information and the payment for the permit, only waiting for call for the visit and the inspection the department, okay?
All right. So, not surprisingly, we'll do, my order will reflect the same as the previous two cases. First, I again find proper notice. Second, I again find the property remains in violation as cited. And finally, I will allow 30 additional days to get the inspection done, get the property into compliance. After that, daily fines of $200 per day will be assessed until compliance is achieved. And we have one more.
Yes, I believe number 36, 1727 Village Boulevard, number 108, CE 22050126. Is that correct?
Again, like previous cases, this property was cited for failure to obtain a rental license and certificate of use. Property on City Hall was posted on 6/21/2022. There is an active application in the system for a license, which was paid for on 7/1. Contact was made via email with instructions on 6/27. The city is requesting 30 days to come into compliance or $200 a day thereafter.
Officer Levine, I apologize that went so quickly. Did you say that certified and regular mail was sent?
Certified and regular mail was sent, yes, and returned.
Thank you. And is there an executed affidavit of posting in the file?
Yes.
Thank you. And Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, application, and emails.
All right, thank you. Those documents are made part of the record. One more time.
My name is Jacob Rodriguez. I just send all documentation and the payment for rental permit. I need to waiting for the inspection.
Okay. So again, the city has proper notice in this case. I find the property remains in violation as cited. I will allow 30 additional days for compliance. After that, daily fines of $200 per day until compliance is achieved. Looks like you got 4 properties to get those inspections done in the next 30 days.
Okay.
All right, thank you very much, sir.
Sir, here's a copy of the orders. Okay. Next case number 10-913 6th Street, CE 22050034, number 10-913 6th Street.
Good morning, Officer Luster, West Palm Code.
Morning.
Property case started on 5/5/2022. City Hall, and property was posted on 6/16/2022. Certified mail did come back signed on 5/9/2022. I've had contact with the owner of the property, which is here today. This case started on the fact that the property had been basically squatters moved in. And the police was involved in the case and is still involved in the case. And the owner has filed eviction for the tenancies that's there. Everything on the property that was cited has come into compliance except for the garbage can in public placement and the rental license and the COU. The property has had the inspection for the rental license, and it failed for the following items: water heaters, all 3 units, refrigerators in 2 units, insect for spraying for roaches, and a toilet not working in 1 unit. I'm asking for the 60 days or $100 per day.
I heard, so is it 18-162A that's still in violation? And
18162A rental license and 2232A certificate of use, and 7434A1J garbage can placement.
So those 3, but everything else complied?
Yes, sir.
Okay. And now you're recommending 60 days,
Yes, sir.
$100 a day after that?
Yes, sir. He's filed for the eviction, and quite sure it's gonna take a little more time. And once that happens, I'll go back and re-inspect the units.
Thank you.
Okay?
Officer Luster, is there an executed affidavit of posting in your file?
Yes, ma'am.
And for the garbage can placement, is it, why do you believe it's an alleged violation? What is it about the garbage can?
They're continuously kept at the roadway or in the front of the property.
Very good. We're seeing some photos while you've been testifying. Do these photos accurately and consistently represent your observations of the alleged violations on the property?
Yes, ma'am.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, thank you. Those documents are part of the record in this case. Good morning, sir. If you could tell me your name and address, please.
Yes, my name is David Pinnell, and it's 913 6th Street, West Palm Beach.
Thank you, sir. Go ahead.
I have a packet for you, Your Honor, I'd like to give to you. Just,
All right, why don't you, has
Is
Ms.
it-
Luster seen it yet?
Is it the eviction?
It's just everything you have.
Okay, I put everything to the case. Everything you sent me has already been scanned into the case.
There's some pictures here, and it's in my affidavit. I filed the police report and the lawsuit. I don't know if she has a full lawsuit. That'll be fine.
I don't have a lawsuit. Okay. That's fine.
So, affidavit of non-rental property, which includes a police report and a copy of the complaint for forcible entry / unlawful detainer, which was filed on May 31st of this year. In addition, we have, it's like 2 color photographs.
A little before and after. I've
Yes,
sent
sir.
those to her.
Yeah. Did a great job on bringing it back.
You've seen all these documents, is there any objection?
Everything he sent me, I put into the file. Yes, sir. I've seen the eviction.
So it's actually already in the file?
Yeah, I
But
scanned it in already.
Then this is already part of the record, but it,
Okay, I'm not sure she had the complete lawsuit, yeah, because it kind of got updated a little bit, so I believe that one might not be the whole updated, matter of fact.
okay.
If it's something that's not already scanned, we'll scan it into the case itself.
I will make this part of the record, sir. Go ahead.
Okay. Well, I think Ms. Luster clarified also that we rectified all the issues except for the garbage cans. That was a little difficulty because I've got squatters in there and they're just doing what they want to do. So no matter what we try to fix, they seem to mess it up. So I think everything's been rectified except for the rental license situation. So we filed an affidavit with the city attorney, letting her know that we're not receiving any income from this property, never did. I don't know who these people are. They broke the locks and moved themselves in, and we're doing everything in our power to get rid of them. We're working on getting a final judgment so we can get them removed from the property. And I guess there was some kind of clarification that these people were trying to rent from me, or one person had said, I'm not sure, but there must be a little misunderstanding because I don't know who these people are. I've never met them. I've never talked to them on the phone, so I just want to put that on record. I don't know who they are. We've had a lot of difficulties trying to get in there and get in compliance with the rental license because of these people. So I just want to put that on record. And that's about it here. I do have my attorney I'd like to speak with before we make a final decision here on call.
All right, let me ask, also, according to your affidavit, that your intent is not to rent the property until it's fully renovated?
Correct.
Okay, and that is...
That's always been my intent from the beginning.
Understood.
And I have that in letters going back and forth to Mrs. Luster as well.
So where are you in terms of renovation, in terms of...
We're getting closer. You know, we would like to have the 60 days just to make sure we get these people out, but I'm thinking we're going to finish it up a lot sooner.
So have you applied, you have applied for the rental license?
Yeah.
Oh, yes.
Okay.
We passed the fire inspection. Everything's been passed, and, you know, if there wasn't people in there, we would have gotten it done. But, you know, I never intended to rent anything, and according to the ordinance, as I understand, I'm not receiving any money, I'm not renting it, so we're trying to find out, well, why do we need a rental license? You know, I mean, I'm taking care of the squatters, I guess.
So you've never rented it up through
Never.
this moment?
I just bought the property, and we're just rehabbing it. We want to get it rented out eventually, once it's fully rehabbed.
So that actually is my question to the city as well, if he's not...
Well, what happened initially, once I realized people were actually living in the unit, I didn't know they were not squatters. So I'm under the impression once someone moves into a unit, I check and make sure whether it has a license or not, and if it does not, then I will write the violation accordingly. Once I spoke to Mr. Purnell the first time, I instructed him, I said, well, if you have no intentions of actually renting to these people until after your renovation, then just don't do it. But he still filled out the application, requested the inspection for the rental license, and I followed through. The properties failed for those reasons. So the application was applied for. Whether they're empty or full, it has to come into compliance regardless. If it's tenancy or not.
I'm sure I understand the city's position. If I'm a property owner and I'm not renting it and I'm not ready to rent it, but I want to be proactive and apply for the application, you're going to find me in violation of the code if I don't pass the inspection, even though I have no intention of renting it until some point in the future. That's what I'm hearing.
But
And
it's
that doesn't
people
make any
residing
sense to me
there.
at all.
We don't know that they're squatters. So once you,
Well, I
your
thought your
place,
testimony right out of the box was that they were squatters and that the police...
yeah,
were
that's what I
involved.
found out after the fact. That was after the fact.
But now we're here today, and the city's asking me to find them in violation of the rental license when there's no renting going on. And what I'm hearing is you have a property owner that's trying to be proactive and get his ducks in a row so that at such time as the evictions are done and the squatters are removed and the property's renovated, he'll be ready to rent it. But I'm having a hard time understanding how he's in violation of the city's code today.
Well, this code does
Doing
read
that.
for profit or nonprofit, the license. It does read that way. So he's not receiving rent, but the code also reads for profit or not profit, the license.
Also talks about running a business, and I'm not running a business. I have no renters. It says you have to have renters. You have to have it leased. I'm not leasing it.
Well, Mr. Purnell applied for the rental license. So once he applied for the rental license, we had to follow through on the inspections.
No, I understand, and I have no problem with that. I guess where I'm having difficulty is, okay, the rental license process hasn't completed yet, and
No.
and inspections have failed, but that doesn't change the fact that he's never actually rented it to anybody, or has, based on the evidence that I have before me this morning, has no intention to rent it until such time as the renovations are complete. So the fact that the inspections have failed is where I'm struggling to see why he's in violation of the code, when the fact of the matter is there's no rental activity. He has no tenants. He has illegal squatters, but he has no tenants, whether he's making money or not. So that's where I'm having a difficult time finding him in violation of that.
I had the same problem, but once I asked him why you're following through with the rental license, his intent was to rent the building, but not to the persons that's inside. So like I explained to him, if that's your intent to rent it, you may as well be ahead of the game. Get your inspections, have the unit ready for when you do evict your place is already past your inspections. Mr. Pennell was under the understanding that if he's not going to rent it, but he still have the people inside, you apply for the rental license. That tells me one thing: your intent is to rent it. For as renovating the units, they're practically ready.
And I don't think anybody's disputing an intention to rent it when the
that's his
renovations are
intent.
complete.
That's correct,
and
sir.
the squatter problem is resolved.
Okay.
I don't think that makes him
You could have waited.
in code enforcement, puts him in code enforcement land for the rental license process at this point in time. Now, if you get to the point where the renovations are complete and you actually take in a tenant and you don't have the rental license in line, then certainly there would be a code violation.
Well, the one reason why the rental license had to stick, in my opinion, is because when I had several conversations with Mr. Pennell, at one point, everybody was leaving the unit. At one point, he may consider keeping, and once he got into that posture of maybe keeping a tenant or some tenants because they are doing well and keeping the place up, that made me stick to keeping the rental license in place.
Sir, Your Honor, I want to clarify something, because that's where the misunderstanding is. We have emails going back and forth, and she has been working with me great, but I never said I would rent to those people. I would have spent all the money to evict them and all the time. I never said that. I never intended. I never talked to these people.
So that I think I'm very clear, but let me be very, very clear. Any human beings that are sleeping there at night are against your permission.
That's correct.
They're not allowed to be there.
Yeah,
You are
they
trying to-
broke in, according to the neighbors, and they're telling people stories. If you read the police report,
Yep.
they're renting from this person, Marcus. Then they answer to our lawsuit that they're renting from Tony Lewis. And now, one of them told, when she went over, that they're renting from me. I don't know who they are. So they're renting for every day somebody different. It's ludicrous.
But you are the sole owner. The other names
Yes.
you mentioned, they do not have ownership rights in the property or rights to
No,
rent
not at all.
the property.
Yeah,
Okay. So, the only person who has rights to rent places in this property is you,
it's me.
and you are not doing so.
I pardon, sir?
And you are not doing so with,
No, I'm not doing so.
Okay.
Special Magistrate, could I have a moment with my client, with the officer?
Yeah.
Sure.
Your Honor, may I speak with my attorney on the phone?
why don't we take a recess? If you want to have a discussion while the city's having a discussion, we can recall the case. That's fine, and I can take another matter while they're talking and you're talking.
Well, if they're only going to be a minute, but before we make a verdict, I would like to speak to her.
All right, I'm going to recall this case. Let's take another case while
Okay,
the respondent speaks to his attorney on the phone, and the city was having a conference as well, so let's call another case in the meantime.
Do
We'll
we
come
have
back to
anyone
this
else
one
here
in a-
for a matter? Any other respondents here? Are you here? Sure. The address?
So there's many homes over there at the property management. They're not in compliance with, the lake that there's green growth out there, so I'm from presidential estates. And part of the agreement is that they're supposed to be in compliance with the lake, and it's not been taken care of. So they said it was gonna be on the docket today.
Do you know around what street it would be?
So, I think it's like, begins with a, I'm not sure of the street, so there's a few different streets.
Right, actually, if you don't mind speaking to Mark Joyce, he's sitting over there, explain it to him. No, that's okay, because I'm not familiar with it.
All right.
Okay, we'll call number 3, 600 South Mangonia Circle, CE 22050164. Number 3, 600 South Mangonia Circle.
Good morning, John Frosco, West Palm Beach Code. This property was declared a chronic nuisance on May 16th of 2022. Certified mail was sent and the property was posted. We did not hear from the owner to submit an action plan that would curtail the nuisance activity. The case is based on a prior adjudicated case of non-compliance. So certified mail was sent for notice of hearing and notice of violation on June 14th of 2022, and the property was posted. As of today, the property is a filthy, unsanitary mess. May have the pictures. That was when it was originally cited, so you can see it was a reoccurring event. And the pictures of today, this morning actually. So the city is requesting that the magistrate formally declare this a chronic nuisance, enter a service order on the property, allowing the city to abate for offenses such as cutting, cleaning, board and securing, whatever is needed to keep the property as compliant as we can.
Is this occupied?
It is not occupied. I believe the owner of the property is deceased.
I see. All right.
Officer
just-
Frasca, I apologize as I was speaking with someone else during a part of your testimony. Can you just briefly tell us about posting and mailing of all notices?
The declaration was posted on May 16th of 2022, and certified mail and regular mail was sent to the tax roll address. And then with no response from the owner or their agent or any responsible party, submitting an action plan, then notice of violation, notice of hearing was sent out and posted. And that was done on June 13th, June 14th, that it was mailed, and it was posted on, also on June 14th.
Just to be clear, that notice of violation was sent by certified and first-class regular?
Yes, it was.
And the posting that you speak of, that's posting at City Hall and at the property, is that accurate?
It's the posting of at the property.
Okay.
The construction of this article states, because it's in fee recovery, it's just posting of the property that's required.
Very good, thank you. Are there executed affidavit of postings in the file?
Yes, there are.
Thank you. And you testified while we were reviewing some photographs. Are those photographs consistent and a true and accurate depiction of your observations of the alleged violation on the property?
Yes, ma'am, they are.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the declaration, as well as the declaration, certified mailings and posting, as well as the notice of violation and the certified mailings, affidavit of posting on that, as well as the photographs.
Those documents are all part of the record in this case. The respondent is not present, however, the city has proper notice. Based on the testimony and the evidence that I have reviewed, I do declare this to be a chronic nuisance. I will enter a service order that authorizes the city to enter the property, abate the nuisance violations, including but not limited to the overgrowth, any trash and debris, securing the property as required, and assessing those costs.
If I may just add one thing, I would like to do an immediate, given the condition, immediate abatement. So if it's entered into the case right away, then I would have the foundation to write the work order to send the contractor out. And, you know, I've had several phone calls on this property, and I agree with the neighbors of
No, it's
its
very clear
condition.
that the overgrowth alone, in my opinion, would constitute a threat to public health, safety, and welfare. Given that this is an unoccupied property, I will authorize immediate entry and abatement.
Thank you, sir.
Sure.
Alright. Back to number 10, 913 6th Street, CE 22050034.
All right, did everybody lawyer up?
We lawyered up.
Okay, where are we?
Okay.
You spoke with your counsel?
Yes.
Is there anything else that you'd like to tell me, sir?
No, just that, you know, regarding the rental license, the reason we did it is because I thought I had to. I mean, we're trying to act and comply and act in good faith. But as you can see by affidavit, and I've never rented, I've never received a penny, and you have my intention, so.
Do you have a sense for when the eviction process will reach a conclusion?
Yes, we've got a default, and I believe 2 already, so we have a writ of possession already. The judge threw it out once he understood what was going on. They're renting from A, now they're renting from B, and apparently we didn't have to have a hearing, but there's still one more they're working on.
Do you think the city was originally recommending a 60-day compliance window for, I mean, there's the garbage can issue to deal with too. Do you think this will all be wrapped up within 60 days in terms of your eviction process?
Yes, sir.
Okay, thank you. Anything else from the city on this one?
Special Magistrate, just very briefly, you know, based on all the testimony that went on before the recall of the case, when it was here originally a few minutes ago, you know, what the city believes it's hearing is kind of the respondent going back and forth. The respondent told the officer that his intent was to keep at least one of the occupants, which means that occupant was already there, and that's a violation of having the occupant there without the rental license. That's why the officer brought this and maintained it in good faith. So the city feels that we have a respondent who's going a little bit back and forth, and it's hard to assess what's really his intention. What's he really going to do? Is he really going to, you know, not be renting, as he now says, things of that nature. So that's why the city is maintaining the case in good faith and believes there is a violation and still asks for the 60 days for all 3 of the violations.
Thank you, and I
Your Honor.
in no way do I believe anybody's done anything in bad faith in this case at all. So let me be clear on that.
Your Honor,
Here,
may I say something?
final shot.
I don't know if you have access to all the emails and certified mails. I never once said I wanted to rent this to any one of those people. Like I said, I would have never gone through the effort. And a matter of fact, I've stated in all my emails to Ms. Luster my intent for the most part, and I documented when I filed these lawsuits in each email. And I never once said that. So that must be a misunderstanding. I don't know where it came from, but that is not true.
Okay.
Okay, I understand.
Matter of fact, you can speak to the officers about it. They know the whole case.
No, I think I've heard enough on this one. And again, I absolutely don't think anybody's done anything inappropriately or in bad faith in terms of the handling of the case. I do find proper notice. The respondent is present. The city has the appropriate notice documents in the file. Based on the testimony and the evidence, I'm going to find that the property remains in violation of City Code 7434A1J regarding garbage can placement, but I'm going to find that there is compliance with all other code sections. I do not find a violation of the rental license or certificate of use requirements based on what I've heard today. Now, as I said, when you get to the point that you are renting and if you don't have those documents lined up, then certainly there would be a violation. But
Yes.
I don't find that that's the posture of the case as we stand here today. I am going to accept the city's recommendation in terms of timing based on your testimony and the city's recommendation. I'll allow 60 days to get the garbage can placement in compliance. Once the eviction process is done, there's no reason that shouldn't be able to be completely resolved. If that violation is not cured within 60 days, though, I am going to impose daily fines of $25 a day until that is complied.
Understood.
All right, thank you, everybody, for that one.
Special Magistrate, can I just note an objection for the record to the 60 days, since it's no longer the rental violation? Normally, if there's a garbage can violation, the city would normally ask for a much smaller amount of time.
I'm going to stick with the 60 days based on all the testimony that I had in this case, though. Thank you.
Thank you, sir.
Okay.
Sir, we have a documentation of
We'll
the,
get an order that memorializes all of that, yeah.
where will we receive that? Or how?
It'll be sent out today to the address of record, the 4701 North Federal Highway.
Okay, great. And could they email that to me
You can write your
possibly?
email down here.
Pardon?
You can write your email down.
Okay.
That's all we have for contested matters at this time. Next case is number 1 is rescheduled, 711 Macy Street, CE 22040234. Number 4 is rescheduled, 1374 13th Street, CE 22060023. Number 5, 1602 45th Street, CE 22050015.
Officer Williams, City of West Palm Beach Code Enforcement. The property at 1602 45th Street was cited originally at May 3rd, 2022. Certified mail was sent out June 7th, 2022. That was received June 21st, 2022. The property, as well as City Hall, was posted on June 23rd, 2022, and an affidavit of posting was prepared and placed in the case file. To date, I've had no contact with the owners. They were originally cited for 18106B for the excessive growth on the property, as well as 18215B, failure to comply. As of this morning, all violations are still current. City is asking for 5 days to bring the property into compliance or an abatement.
This is the vacant lot that I'm
Yes, sir.
looking at, not the building beside it.
Say again?
This is the vacant lot, not the building.
Yes.
Thank you.
Thank you, Officer Williams. With respect to the executed affidavit of posting in the file, does that indicate that the notice of violation was also sent by first-class regular mail?
Yes, ma'am.
Thank you. With respect to your testimony, we've been reviewing some photographs. Could you just briefly describe your observations of what's going on the property?
So the grass on the property is extremely overgrown. There's litter and trash and debris scattered throughout there. It looks like someone came and picked up some of the trash and debris, but it still hasn't been cut.
And the photographs that we've been reviewing, are those photographs true and accurate and consistent depiction of your observations of the property?
Yes, ma'am.
And with respect to your request for an abatement, do you believe this property presents a health, safety, and welfare issue to the community?
Yes, ma'am.
Do you believe that this property is a haven for vermin and other nuisances, attractive nuisances?
Yes, ma'am.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Those documents are made part of the record. I find proper notice with the certified mail and the posting, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. I find that violation does constitute a threat to the public health, safety, and welfare. I will accept the city's recommendation, allow 5 days for compliance. After that, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you, sir.
Number 6, 3215 Pinewood Avenue, CE 22050364.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 3215 Pine was initially cited on 5/28/22. Certified mail was sent on 6/2/22. The certified mail receipt was returned unsigned. The property as well as City Hall was posted on 6/3/22. Property was cited for 94482-A parking requirements. They were parking 3 to 4 vehicles ongoing on unapproved surfaces. As of last evening, I did note that the unapproved parking was continuing. In light of that, the city's requesting 15 additional days in order to comply, or a fine of $100 per day be imposed.
Thank you. Officer Williams, do you have an executed affidavit of posting in your file?
Yes, there is.
And does that affidavit reflect that the notice of violation was also sent by first-class regular mail?
Yes, it does.
Thank you. During your testimony, we've been reviewing some photographs. Do those photographs accurately represent and are a truthful and consistent representation of your observations on the property?
Yes, they are.
And did you observe this alleged violation once or more than once?
I actually observed those violations on at least 2 occasions.
Okay, thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Those documents are all made part of the record. With the posting following the return certified mail, I find the city has proper notice, even though the respondent is not present today. Based on the testimony and the evidence, I find property remains in violation as cited. I will accept the city's recommendation, allow 15 additional days for compliance. After that, daily fines of $100 per day are assessed until compliance is achieved.
Number 73217 Pinewood Avenue, CE 22050365.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 3217 Pinewood was initially cited on 5/28/22. Certified mail was sent on 6/2/22. Certified mail receipt was returned unsigned. The property as well as City Hall was posted on 6/3/22. Property was initially cited for 22-32A certificate of use, 18-100 safe egress as there were boards on the windows, 18-162A rental license violation, and 94-482A parking requirements. As of last evening, the owner of the property, Mr. David Bowden, sent an email indicating that he had taken care of the renewal of the rental license and the certificate of use. I did verify that. So 22-32-A is complied. 18-162A, the rental license violation, is complied, as well as 94-482A, whereas they, at least last evening, there was no unapproved parking noted at the property. 18-100 still in fact remains. There was some boarding to some of the windows. In the email that Mr. Bowden sent me, he indicated that he just needed a couple more days and the boards would be removed. So in light of that, the city is requesting 15 additional days in order to comply, or a fine of $100 per day be imposed.
Thank you, Officer Williams. Does your file reflect that there's an executed affidavit of posting?
Yes, there is.
And does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
And with respect to your testimony about your observations on the property, the photographs that we've been reviewing, are those a true and accurate depiction of the observations that you made of the alleged violations?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and the email, or the emails Officer Williams testified to, received from the respondent.
Those documents are all part of the record in this case. That is granted. City has proper notice with the posting following the returned certified mail, even though the respondent is not present. Based on the testimony and the evidence, I will find the property has complied with the violations cited in the notice, with the exception of City Code 18-100 regarding safe egress, which remains in violation. Based on the testimony, I will accept the city's recommendation, allow 15 additional days for that violation to comply. After that, daily fines of $100 per day are assessed until compliance is achieved.
Number 8, 4200 North Terrace Drive, CE 22050250.
Good morning, Natalie Clark, City of West Palm Beach Code Compliance. 4200 North Terrace Drive was cited on 5/20/2022. The property and City Hall were posted on 5/24 of 2022, and certified mail was signed for on 5/26 of 2022. The property was cited for trash can in public view and bare landscape. I've had contact with the property owner, Scott, and we both agreed on additional 90 days or $100 per day for code section 94442C1, which is the bare landscape. The property has since complied with the trash can placement code section.
Thank you, Officer Clark. Do you have an executed affidavit of posting in your file?
Yes,
And does that affidavit indicate that the notice of violation was also sent via first-class regular mail?
yes.
And with respect to the photographs that we've been reviewing during your testimony, can you just briefly just tell us about the landscaping that you're seeing?
So basically, as you can see, that island area is the only area that has landscaping. It's just dirt. There's no grass or plant material there. So he has planted grass seeds, and he does plan on putting in additional plant coverage. It just hasn't grown in as yet. But as you see in the pictures taken after those ones, you can see where it's growing in. It just hasn't covered the entire areas yet.
Is that side of the property the only problematic part, or we're seeing something else here too?
That's the only problematic part.
Okay, very good. And do the photographs accurately and truthfully represent your observations on the property?
It does.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you. Those documents are made part of the record. City has proper notice with the certified mail and posting, even though the respondent is not present. Based on the testimony and the evidence, I will find the property remains in violation of City Code 94442C1, but has complied with City Code 7434A1H. I will accept the city's recommendation, allow 90 additional days for compliance with the outstanding violation. After that, daily fines of $100 per day are assessed until compliance is achieved.
Number 9, 3417 Australian Court, CE 22060228.
Natalie Clark, City of West Palm Beach Code Compliance. 3417 Australian Court was cited on 6/17/2022. The property and City Hall were posted on 6/27 of 2022, and certified mail was sent on 6/22 of 2022. The property was cited for overgrown swale/parkway and excessive growth. I've had no contact with the property owner. The property is still in violation of both code sections. However, they have started cutting some sections of the overgrowth. The city is asking for an additional 10 days or $100 per day until compliance is achieved.
Thank you, Officer Clark. Do you have an executed affidavit of posting in your file?
Yes, I do.
Does that affidavit reflect that the notice of violation was also sent via regular first-class mail?
It does.
And we've been reviewing some photographs while you've been testifying. Do those photographs truthfully and accurately represent, and are they consistent with your observations on the property?
Yes, they do.
Can you just take a moment and briefly describe the overgrowth, or excuse me, the excessive growth that you're seeing in addition to what you're seeing on the parkway or swale?
So the property is vacant, and it just hasn't been getting cut as frequently as it should. And as you can see here, that's the swale area that's overgrown, and sections of the actual landscaping is also overgrown. Can you include this picture? As you can see, it's overgrown here.
So when you say it's overgrown here, you're referencing that up on the actual lawn near the structure?
Yes.
Okay.
It's just not being cut. Like, as you can see there as well, you can barely see the sidewalk. The vegetation is higher than the 6-inch standard.
Great, thank you so much. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you.
Thank you. Those documents are made part of the record. City has proper notice with the certified mail and posting, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. Given the testimony that the respondent has started making some corrective action, I will accept the city's recommendation, allow 10 additional days for compliance. After that, daily fines of $100 per day are assessed until compliance is achieved.
Thank you.
Number 11, 1210 Palm Beach Lakes Boulevard, F4, CE 22060011.
Officer Lester, West Palm Code. This case was started on 6/1/2022. Certified mail was signed on 6/6/2022. Property was posted on 6/16/2022. City Hall was also posted on 6/16/2022. I've had no contact with the owner or management company of the property. This case started from a tenant complaint. In the unit, the property has interior leakage from the upstairs unit affecting this downstairs unit. In the bathroom area, the plumbing fixtures, it's causing, I don't know what's going on in the upstairs unit, but the downstairs unit is being affected by all of the, I don't know if it's the waste line or the water line, because it's technically covering that downstairs unit ceiling. And it's now affecting the walls in that bathroom. So it's the drainage. Also, I've cited it for the fence maintenance. The front gate on the apartment complex is broken. It constantly is just hanging there. The owner keeping up the plumbing in good repair and cleaning sanitary conditions for its pests. She's having a lot of roaches. Roaches love moisture. Once moisture becomes inundated, you're going to have roaches. I'm asking for 30 days or $100 per day to come into compliance.
Thank you, Officer Luster. Is there an executed affidavit of posting in your file?
Yes, ma'am.
Does that affidavit also reflect that the notice of violation was sent via regular first-class mail?
Yes, ma'am.
And with respect to the photographs that we've been reviewing during your testimony, are those photographs a true and accurate representation, and are they consistent with your observations of the property?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, and photographs.
Thank you. Those documents are made part of the record. With the signed certified mail and the posting, the city has proper notice, even though the respondent is not present at today's hearing. Based on the testimony and the evidence, I find property remains in violation as cited. I will accept the city's recommendation, allow 30 days for compliance. After that, daily fines of $100 per day are assessed until compliance is achieved.
Thank you.
Number 12, 811 7th Street, CE 22060078.
Officer Luster, West Palm Code. Case started on 6/7/2022. Cert mail was returned to us on 6/17/2022. Property was posted on 6/7/2022, and so was City Hall on 6/7/2022. This property was cited for litter, trash, and debris, overgrowth, tree obstruction of right-of-way, cleaning up one half of easement, alley to road, contractor's waste, and removal of a derelict sign. I'm asking for 10 days or an abatement.
Thank you, Officer Luster. Do you have an executed affidavit of posting in the file?
Yes, ma'am.
Does the affidavit reflect that the notice of violation was also sent via regular first-class mail?
Yes, ma'am.
And with respect to your request for abatement, do you believe this is a vacant property?
Yes, ma'am.
Do you believe that the conditions on the property constitute a health, safety, and welfare issue for the community?
Absolutely.
Do you believe that the condition on the property is a habitat for vermin and otherwise an attractive nuisance for other invasive
Animals.
things,
Yeah,
critters?
things. Yes, ma'am.
And can you just briefly describe what you're seeing from the photographs that we're
It's
looking at.
severely overgrown, excessively. It's tons of trash and debris on it. It was some kind of builder sign that's actually coming apart, and that's what's falling on the ground, the sign itself. And in the easement, the alley, I should say, the overgrowth is just getting into the roadway, and so on the swell also.
Thank you. And is it your testimony that the photographs accurately and truthfully and consistently represent the observations you've made on the property?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you. Those documents are made part of the record in this case. With the posting following the return certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I find the property remains in violation as cited. I find that those violations constitute a threat to the public health, safety, and welfare. I will accept the city's recommendation, allow the respondent 10 additional days to comply. After that, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you.
Yes, ma'am.
Number 13 is complied, 3021 Pinewood Avenue, CE 22030189. Number 14 is complied, 803 32nd Street, CE 22040132. Number 15 is complied, 510 44th Street, CE 22040199. Number 16, 5811 Broadway, CE 22030211.
Robert.
Number 16, 5811 Broadway.
Robert Watkins, City of West Palm Beach Code Compliance. This property was cited March the 11th. Certified mail was sent March 14th. Certified mail was received March 16th. City Hall was posted on June 6th. This property was cited for external doors and windows. It was also cited for clean and sanitary, excessive growth, and fence and wall maintenance. And in 18-105A, which is all non-residential buildings should be impervious to water and water getting in and rotting and rodent intrusion. I've had one conversation with the owner. He didn't seem too interested in getting the property fixed because he told me he was going to be selling it, and I haven't heard anything else. After that point, I reached out again via phone. I left a voicemail to see if he was going to fix anything or he needed time. I didn't get any response. So on this, the city is requesting 20 days or fines at $200 per day after.
Thank you, Officer Watkins. Is there an executed affidavit of posting in your file?
Yes.
Does that affidavit reflect that the notice of violation was also sent via regular first-class mail?
Yes.
Does that affidavit also reflect that the notice of violation was posted at the property?
Yes, it does.
And can you please testify briefly about your observations on the property that support these alleged violations?
There's a fence on the east side of the property that's off track and hanging. Also, on the south side, there looks like a vehicle, I guess, had ran into it and it was crushed and pushed in. And on the other side as well, shows of that nature. And there's also pictures of, you can see the roofs falling in on both sides of the property, and it seems to be rotted, basically just rotted and falling apart. I've gotten a few complaints actually on this from the Northwood Hills Association too, and reference to vagrants living there, but I didn't see anyone that was there.
You said you did not see vagrants?
Yeah, because that's how I got the original complaint. It was an email and phone call from
Oh,
Northwood.
I didn't hear you right.
Oh, yeah, sorry about that. Yeah, that was the original, but yeah, there weren't any people living there, but just the condition of the property.
That was the complaint, but you didn't see it?
Yeah, I did.
Gotcha.
And Officer Watkins, what are your observations regarding trash and debris and grass and weeds?
There's trash and debris along the fence line. There's also weeds and overgrowth, even trees growing out the roof in the front. When you look at the front picture, there's two trees that are
I was
actually
wondering,
growing
is that
out.
a tree actually coming out
Yeah,
of the
yeah,
roof?
it's actually, it's growing out of it, so.
Thank you. And Officer Watkins, the photographs that we have been reviewing, are those photographs a true and accurate and consistent depiction and representation of your observations on the property.
Yes, everything that I saw while I was there.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you. Those documents are made part of the record. With the received certified mail, the city has proper notice, even though the respondent is not present at today's hearing. Based on the testimony and the evidence, the property remains in violation as cited. I will accept the city's recommendation. They'll require compliance within 20 days. After that, daily fines of $200 per day are assessed until compliance is achieved.
Number 17, 703 43rd Street, CE 22030348.
City of West Beach Code Compliance, Robert Watkins. This property was cited on March 21st. Certified mail was sent March 22nd. Certified mail was received March 24th. City Hall was posted June 6th. This property was cited for landscape areas, must be landscape or grass, and removal of artificial turf. I've had no correspondence with the homeowner. All violations are still present as of yesterday. The city is requesting 30 additional days or $100 per day after.
Thank you, Officer Watkins. Do you have an executed affidavit of posting in the file?
Yes.
Does that affidavit reflect that the notice of violation was sent, and I apologize if this is cumulative, by certified and regular mail?
Yes, ma'am.
And does the affidavit reflect that the notice of violation was posted at the property and City Hall?
Yes.
And can you just briefly describe what your observations are on the property regarding your the alleged violations?
There's a island of artificial turf with a palm tree sticking out. There's lots of small white rocks and pavers over the whole front.
And so the artificial turf is in the front yard, is that accurate?
Yeah, it's right there.
Okay, and you can see that right from the street or the sidewalk?
Yeah, it's the only green patch in the whole yard.
Okay, and the pavers, is it your testimony that it's the amount of pavers, the volume, the...
Oh yeah, they're everywhere. Yeah, that's, I guess they took up the landscaping and just put all arid desert style landscaping there.
Thank you. And the photographs that we have been reviewing, are those a truthful and accurate and consistent depiction of your observations on the property?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, thank you. Those documents are made part of the record. The city has proper notice with the posting and the certified mail, even though the respondent is not present. Based on the testimony and the evidence, I will find the property remains in violation as cited. Man, that artificial turf is just the gift that keeps on giving, isn't it? I will accept the city's recommendation in this case, require compliance within 30 days. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Number 18 is complied, 523 48th Street, CE 22030406. Number 19 is rescheduled, 633 55th Street, CE 22030457. Number 20, 6905 South Dixie Highway, CE 22050195.
Good morning, Sandy Smith, Code Enforcement Officer for the City of West Palm Beach, presenting on behalf of Joseph Oliva. This property was cited on May 18, 2022. Service was accomplished by certified mail sent on 5/19/2022. Certified mail was returned on June 3rd, 2022. In addition, both property and City Hall were posted on 5/19/2022. I have not been in contact with the owner of the property. The affidavit, a copy of the affidavit of posting was placed on file. The property was cited for prohibited artificial plant material on building/structure, and that's code 94-445-3. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 60 days for them to come into compliance. If they do not come into compliance, then the city is asking for $100 until compliance is achieved.
Thank you. Officer, with respect to your affidavit of posting, Does it reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Okay. And we've been reviewing some photographs during your testimony. Can you describe your observations at the property that lead you to believe that this is an alleged violation?
Sure. Yes, they do have artificial material on the facing of the building. And we also have a picture in there for the original permit that was issued in March of 2019, showing what it should look like. And I guess they deviated from what the original plan was and put artificial material on the front.
Okay.
Joseph Oliva, Code Enforcement Officer. We also have we spoke with Ray Caranci, who's the West Palm Beach certified arborist, and he gave us the code basically of what that is on the structure. It's not considered artificial turf. It's a non. We have it right here. Yeah, it's a non-organic plant material which is prohibited, and she did give you the code number for it.
And officers we're reviewing right now, is that the prior permit and information that you're testifying about?
That's correct.
Okay, and is that a part of the file?
Yes.
Okay. And officer, are the photographs that we've been reviewing, are those a true and accurate and consistent representation of your observations of the alleged violations on the property?
Yes, it is.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and the packet of the permit and documentation in the file regarding this issue.
All right, those documents are made part of the record. This is one of those, you think you've seen it all. I'm actually impressed that there's a code section that addresses this. That's not I've never seen this before.
It's a first for us, too. It's like...
and it seemed pretty clear from the development approval paperwork that was not part of the approved site plan.
Right.
That non-organic plant material wall covering. So, okay, well, I will find proper notice with the certified mail and the posting, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. I will accept the city's recommendation, require compliance within 60 days. After that, daily fines of $100 per day are assessed until compliance is achieved.
Thank you.
Thanks.
Number 217711 South Flagler Drive, CE 22050196.
Good morning, Todd Underwood, City West Palm Beach Code Enforcement Officer, representing this case for Joe Olivia. He's present here with me also. This property was cited on 5/18/2022 for prohibited artificial turf in the front yard, 94-451-D. It was, certified mail was sent out on 5/19/2022. Certified mail was signed and returned on 5/23/22. City Hall and the property were posted on 5/19/2022. We have not been in contact with the property owner.
You said no contact?
We have not had contact.
Thank you.
Correct. As of this morning, we have not had compliance with the property, and the city is asking for 60 days of time or $100 per day after that until compliance is achieved.
Thank you. Officer, is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit also reflect that the notice of violation was sent via regular first-class mail?
Yes, it does.
With respect to the photographs that we've been reviewing, are those photographs a true and accurate and consistent representation of your observations on the property?
Yes, those are the ones.
And with respect to those photographs, is the artificial turf, is it just those
In
the
between,
turf in between the
yes.
pavers
And on the side, and it was like on the side of the pavers too.
and on the side of the pavers?
Yeah, see the side piece up at the top there?
Okay. And all of this is in the front of the house
Yes,
and can be viewed from the street or the sidewalk?
yes.
Okay. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, those documents are part of the record. I will find proper notice in this case, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. Like I said, the gift that keeps on giving. I will accept the city's recommendation, require compliance within 60 days. After that, if compliance has not been achieved, there will be daily fines of $100 per day until compliance is met.
Thank you.
Thank you.
Number 22 is complied, 417 Barnett Street, CE 22050288. Number 23, 625 Forest Hill Boulevard, CE 22060010.
Good morning, Alex Oliver, Code Enforcement Officer, presenting this case in lieu of Joseph Oliva, who's next to me. This property was cited on June 1st, 2022. Service was accomplished by certified mail sent on July 2nd, 2022. Certified mail was signed and signed for COVID. Both property and City Hall were posted on June 2nd, 2022. A copy of the affidavit was added to the file, and there has been no contact with the property of the owner. Case number is CE 220-60010. Address 625 Forest Hill, and the owner is Stephanie Gomez, Inspector Joseph Oliva. This property was cited for 482A, unpaid parking. As of this morning, the property has not come into compliance. Therefore, the city is asking for one-time fee of $75. Also, the city is requesting a finding of fact.
Thank you, Officer. With respect to the affidavit of posting, which is in the file, does that affidavit also reflect that the notice of violation was sent via regular first-class mail?
Yes.
Okay. And with respect to this alleged observation on the property, what did you observe that is the alleged violation?
There's a car parked on the grass on the left side, and also we did see at some point.
We went by a couple of times and did a couple of inspections, and there was cars parked on the left side of the property, and there were different cars.
Yeah, different cars, differently.
Okay. And did I hear accurately, it was a little hard to hear, that you're asking for the $75 one-time fee and a finding of fact?
Yes, because it's a reoccurrence violation, basically, and if we do just like a 10-day or, like $50 fine, they move the car, then we close the case and we have to reopen it. So we want to do this as a one-time fine of $75 and get a finding of fact.
And how recently did you observe the reoccurrence?
Within this whole month, basically.
I understand. So that
a few inspections.
Okay, and so that was after the date of required compliance in the notice. Is that accurate? And Officer, the photographs that we've been reviewing, are those a true, accurate, and consistent representation of your observations on the property?
Yes.
Thank you so much. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, those documents are part of the record in this case. I will find proper notice with the certified mail that was signed, even though the respondent is not present at today's hearing. Based on the testimony and the evidence, I do find the property certainly was in violation. I understand the problem here with it coming off, going back on. So I will accept the city's recommendation, impose a one-time $75 fine. Any future violations will then be able to be repeats. Okay.
Thank you.
Number 24, 4401 Garden Avenue, CE 22050028.
Hello, Richard Pasmino, City of West Palm Beach Code Enforcement. This is a church. The property was cited on May 4th. Certified mail was sent out May 5th. It was signed received May 9th. In addition, the property and City Hall were both posted on May 5th. This property was cited, it came in as a complaint from one of the neighbors. For exterior paint required, there's peeling, missing paint all over the building. Clean and sanitary. There's common areas that need to be pressure washed, including the sidewalk. External doors and windows. There are some boards on a window. Junk and abandoned vehicle. There's an inoperative vehicle being parked and stored on the property. And the paved and marked parking. The parking lot at the property, it's in poor condition. It needs some holes patched, and the striping might need to be repainted. The city's recommending 60 additional days. I've had no contact. 60 additional days or a fine of $150 a day. Still in full violation.
Thank you, officer. Does your file reflect an executed affidavit of posting?
Yes, it does.
Does that affidavit reflect that the notice was also sent via regular first-class mail?
Yes, it does.
With respect to your testimony, we were reviewing photographs while you were speaking. Do those photographs truthfully, accurately, and consistently depict and represent your observations of the alleged violations on the property?
Yes, they do.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Those documents are made part of the record. I will find proper notice with the signed certified mail, even though the respondent is not present. Is the junk abandoned vehicle, is that a registration issue, or is it truly a, like?
It's a registration issue. It's that white SUV. It never leaves. It's
I
just
saw the
parked
white
in store
SUV,
there.
that's the vehicle in
Yeah,
question?
yes.
Okay. Okay, based on the testimony and the evidence, I do find the property remains in violation as cited. I will accept the city's recommendation in this case, require compliance within 60 days. After that, daily fines of $150 per day are assessed until compliance is achieved.
Number 254408 Garden Avenue, CE 22050029.
Richard Pasmino, City of West Palm Beach Code Enforcement. This is a parking lot across the street from that church, also owned by the church. It came in as a complaint. It was cited on May 4th. Certified mail was sent out May 5th. It was signed received May 9th. In addition, the property and City Hall were both posted on May 5th. This property was cited for clean and sanitary conditions. There's trash and debris all over the parking lot. Inoperative vehicles. Fence maintenance. Landscaping maintenance, dead, missing vegetation, overgrown weeds, and paved and marked parking. The parking lot, it's in poor condition as well. The parking spaces are not, the lines are all faded and missing. I've had no contact as well. All violations remain except for 34102A. The inoperative vehicles were removed. The city's recommending 60 additional days to comply with all violations, or a fine of $150 a day.
Thank you. Officer, does your file reflect an executed affidavit of posting?
Yes, it does.
Does that affidavit reflect that the notice of violation was also sent via regular first-class mail?
Yes.
With respect to the photographs that we've been reviewing during your testimony, do those photographs truthfully and accurately depict and represent the alleged violations that you've observed on the property?
Yes, they do.
And can you just briefly describe, I may have missed it, the issue with the fence?
It's that black fence right going into the parking lot. It's damaged in that area.
Okay, thank you so much.
Been no changes in regard to it.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, those documents are made part of the record. With the signed certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. Did you say 60 days for this one as well?
Yes, 60 days or 150.
Yeah. I will accept that recommendation. I will order compliance within 60 days. After that, daily fines of $150 per day are assessed until compliance is achieved.
Number 26, 4811 Parker Avenue, CE 22050226.
Richard Pazmino, City of West Palm Beach Code Enforcement. This property was cited on May 20th. Certified mail was sent out May 23rd. It was returned May 30th. But in addition, the property and City Hall were both posted on May 23rd. This property was cited for exterior walls, needed repair, exterior windows needing repair, trash and debris on the property, junk inoperative vehicle, fence maintenance. There was a damaged chain link fence, the front parking lot needs to be a non-dusting surface. It was deteriorating with a lot of potholes, loose gravel, vehicle repair in residential district, and outdoor storage. I have been in contact with the resident. It's the owner's son. And since I cited the property, code sections 18106A, 34102A, and 94482A, and 94485A, have come into compliance. The exterior repairs have began, but they're requesting more time. The city's recommending 90 days to come into compliance, or a fine of $150 a day.
Thank you. Officer, does your file reflect an executed affidavit of posting?
Yes.
Does that affidavit also indicate that the notice of violation was sent via regular first-class mail?
Yes, it does.
With respect to the remaining alleged violations of clean and sanitary, junk and abandoned vehicle, no, back up. I think the repairs to the roof, walls, doors, windows, and the fence and the outdoor storage are still the ones that are outstanding. Is that accurate?
Yes, the outdoor storage, the fence maintenance, and the external doors and external walls.
Thank you. Could you just briefly describe a little bit more about your observations supporting each allegation?
So I first noticed the property had boards where a wall should be. I cited it. It turns out a drunk driver crashed into their house. Once I got in contact, the resident took the car off the jack, put the tires on, filled in the potholes with concrete, and he is working on getting the repairs done. And it looks like he's almost there.
And with respect to the fence, where is that?
There should be a chain link right between that post to the gate.
Oh, okay, so that's in the front yard?
Yes.
Totally missing section of the fence, is that accurate?
Yes.
Okay, and what about the outdoor storage, do you believe was in violation?
At first, there was, they were keeping some, I think in the front, there was like some propane tanks, some trash along the side. The original stuff was moved, but that plywood that they were using to board is now being kept on the side, visible to the public.
Thank you. And the photographs that we've been reviewing, are those photographs a true and accurate and consistent representation and depiction of the alleged violations that you've observed on the property?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you. Those are made part of the record. I just want to make sure I got this right. 18106A, 34102A, 94482A, and 94485A are the complied code sections. Is that right?
Yes.
Okay. All right. Back to notice. I do find proper notice with the posting following the return certified mail, even though the respondent is not present. Based on the testimony and the evidence, I find the property remains in violation of City Code Sections 18103B and E, 94302A4, In 9471C, I find the property has complied with the other 4 code sections that were cited. I'll accept the city's recommendation, require compliance within 90 days. After that, daily fines of $150 per day are assessed until compliance is achieved.
Thank you.
Number 28 is complied, 550 Okeechobee Boulevard, 1011 CE 220203882. Number 29, 433 32nd Street, CE 220300411.
All right. Don Williams, Code Enforcement. I cited this property, 433 32nd Street on March 23rd of 22. Certified mail sent May 14th of 22. The property in City Hall was posted June 7th of 22. This is a renewal of a rental license. I had contact with the owner, and for some reason she has not renewed those licenses or paid the fee. It's gonna be asking 10 days for her to do that, or $100 a day after that.
Thank you, officer. Is there also an executed affidavit of posting in your file?
Yes.
And does that affidavit reflect that the notice of violation was also sent via regular first-class mail?
Yes.
And during your contact with the owner, did she dispute or otherwise object to the fact that there is current rental?
No.
Okay. And I believe that we reviewed a photograph of posting. Is that a true and accurate depiction of the posting of the property at issue?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, and photographs.
Thank you. Those documents are made part of the record. With the posting and the certified mail, the city has proper notice even though the respondent is not present. Based on the testimony and the evidence, I will find the property remains in violation as cited. I will accept the city's recommendation, allow 10 additional days for compliance. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Number 30 is complied, 3217 Pinewood Avenue, CE 220300415. Number 31, 3518 Broadway, CE 220300445.
Don Williams, Code Enforcement. This property at 3518 Broadway was cited on March 24th of 22. Certified mail was sent May 13th of 22. The property in City Hall posted June 7th of 22. This is a renewal of a business tax. I did visit the property and spoke with an employee at the time who indicated that the owner is out of town, but they would actually renew it once they return. But that has not happened. So my request is 10 days to comply that, or $100 a day after.
Officer, is there an executed affidavit of posting in your file?
Yes.
And does that affidavit reflect that the notice of violation was also sent via regular first-class mail?
Yes.
What is the name of the business that's at issue today?
The business name is Palm Beach Maternity Center.
Thank you. And the photograph that we've reviewed, is that an accurate,
It's accurate, yes.
I'm sorry, I was trying to read that while I'm sorry. Is it an accurate and truthful representation of the posting of the notice of violation in this file?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
All right, those are made part of the record. I will find proper notice with the posting in the certified mail. Based on the testimony, I will find that the property is in violation of 82-144, renewing the business tax. Would this be a one-time as opposed to a daily recurring?
No, it's a COU, so that would be additional, ongoing. You have a COU attached to this.
My understanding is the certificate of use could have a recurring daily fine, but a business tax renewal delinquency is a one-time fine.
I was only requesting the ongoing 10-day.
I have no problem with the 10 days to comply, but I don't think, or you can do a daily recurring fine on this. I think it has to be a one-time.
We can do one time on the business tax of $250 and the ongoing COU at $100 after 10 days.
Oh, I didn't see certificate of use on this one.
All right, which one is this one? Let me back it up real quick.
Just showing 82,144 business tax receipt, which I will assess the one-time fine of $250.
Correct. I thought I cited it for the COU, but it's not cited for the COU, so you are correct.
Okay.
Just the one-time fine's fine.
Okay, so ordered. Thank you.
Number 32, 605 Belvedere Road, number 12, United Investigator, CE 22050374.
Okay. 605 Belvedere, Don Williams Code Enforcement, was cited on May 31st of 22. Certified mail was received on June 6th of 22, and the property in City Hall posted June 7th of 22. It was cited for a business tax receipt. The business name is United Investigators Group. I did visit the business, and the owner was at the location. I spoke with the owner, and as of today, he has not applied for the renewal of his business tax. So I'm going to be requesting a one-time fine of $250.
Thank you. Officer, does your file reflect an executed affidavit of posting?
It does.
And does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
And the photograph that we looked at, is that an accurate and truthful depiction of the posting at the property?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Thank you. Those are made part of the record in this case. With the posting in the certified mail, the city has proper notice. Even though the respondent is not present, based on the testimony, I will find the property remains in violation of City Code 82-144 for failing to renew business tax receipt. I will assess a one-time fine of $250.
Thank you, sir.
Yes, sir.
Number 33, 3015 North Flagler Drive, CE 22040414.
Good morning once again, Officer Levine, City of West Palm Beach Code. This property was cited for failure to obtain a rental license and certificate of use. Property was, and City Hall was posted on 6/21/2021. Made contact with the owner for an inspection on 6/28/2022, and to date, we have not been able to get this inspection done. There's an active application in the system. The city is requesting 30 days to come into compliance with $200 a day thereafter.
Thank you. Officer, I'm sorry, I may have missed it. Was the notice of violation sent via certified and first-class regular mail?
Yes, ma'am.
Is there an executed affidavit of posting in the file?
Yes.
Thank you. And I believe that we saw a photograph of posting. Is that a truthful and accurate depiction of the posting at the property in question?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, and the current application for the rental license.
All right, those documents are all made part of the record. With the posting in the certified mail, the city has proper notice, even though the respondent is not present at today's hearing. Based on testimony and the evidence, I will find property remains in violation as cited. Tell me again the remedy that you're recommending.
30 days to come into compliance with $200 a day thereafter.
I will accept that recommendation, allow 30 additional days for compliance. After that, daily fines of $200 per day are assessed until compliance is achieved.
Case number 34 is rescheduled, 1749 Village Boulevard, number 106, CE 22050124. Number 35, 1727 Village Boulevard, number 102, CE 22050125.
This property was cited for failure to obtain a rental license and certificate of use. Property and City Hall was posted on 6/21/2022. A license was applied for, but the fees were not paid until 7/1. Made contact with the property owner on 6/27/2022 via email with instructions. To date, we have not been the fee will not paid until 7/1. So the city is requesting 30 days to come into compliance or $200 a day thereafter.
Thank you. Officer, does your file reflect that there's an executed affidavit of posting?
Yes, ma'am.
And does that affidavit reflect and was the notice of violation sent via certified and regular mail?
Yes.
And we've been reviewing some documents while you were testifying. There appears to be an email. Is that between you and the respondent?
Yes, ma'am.
And does that discuss the rental application status?
Yes, ma'am.
Okay. And I believe that we were also looking at the Sunbiz printout.
Yes.
And is that regarding the respondent, Danis Fruta LLC?
Yes.
Okay, thank you. And the photograph in the file, does that truthfully and accurately depict the posting of the notice at the property in question? Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, photographs, emails, Sunbiz printout, and as well, the officer testified to the application submitted.
Those documents are all made part of the record. The city has proper notice. In this case, even though the respondent is not present at today's hearing, based on the testimony and the evidence, I do find the property remains in violation as cited. I'll allow 30 additional days to comply. After that, daily fines of $200 per day are assessed until compliance is achieved.
Number 39, 1701 Village Boulevard, number 111, CE 22050130.
This property was cited for failure to obtain a rental license and certificate of use. The property in City Hall was posted on 6/21/2022. On 6/30, we did an inspection of the property, which the property failed inspection for not having screens in the windows. The property was untidy. The shower was not working. And this particular property manager sent correspondence with inspection checklists as to what we were looking for, and still nothing was done with regards to the property to bring the property into compliance. Magistrate, usually we ask for 30 days, and I'm hoping you could go probably about 15 days on this, because we've been going back and forth with this, and she still has not addressed what we need to have addressed, and she doesn't want to drive from Miami to come up and do the inspection. So city's requesting 15 days to come into compliance at $200 a day thereafter.
Okay.
Thank you, officer. Does your file reflect that there's an executed affidavit of posting?
Yes.
And I apologize if you had said this, I missed it. Does that reflect that the notice of violation was sent via certified and first-class regular mail?
Yes.
And the notice of violation was posted at the property and at City Hall?
Yes, ma'am.
And we've been reviewing emails while you were testifying. Photographs while you were testifying. Do those photographs truthfully and accurately and consistently depict and represent your observations of the inspection of the property?
Yes.
And as well, does it reflect the posting at the property in question?
Yes, ma'am.
And with respect to the correspondence that you indicated you had with the property manager, we looked at an email as well as a attachment of an inspection list. Is that the documents that you're referring to?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, as well as the email and attachment.
Those documents are all made part of the record. City has proper notice in this case. I do find the property remains in violation. As cited, I'll accept the city's recommendation. Under the circumstances, require compliance within 15 days. After that, daily fines of $200 per day until compliance is achieved.
Number 41, 1739 Village Boulevard, number 106, CE 22050133.
This property too is under the same management company, and this property was cited for failure to obtain a rental license and certificate of use. The property was posted, property in City Hall, was posted on 6/21/2022. On 6:30, we did an inspection of the property. The property failed the inspection. The AC was not working properly. The lines were frozen. We have video from the tenant. The sliding door glass screen is broken. We have a window with screens that is not fitting properly. And again, I've sent email correspondence with a checklist to the property management, and still nothing has been done. As the previous case, we are requesting 15 days to come into compliance, or $200 a day thereafter.
Thank you. Officer, does your file reflect an executed affidavit of posting?
Yes, ma'am.
They look like they found this in the trash and just threw it on our, look at this. It doesn't close properly. There's a big gap right here. They literally.
Thank you. Does the affidavit of posting also reflect that the notice of violation was sent via certified and regular first-class mail?
Yes, ma'am.
We've been reviewing some photographs while you've been testifying. Do the photographs accurately and truthfully represent your observations on the property?
Yes.
And the videos that you alluded to that we just saw, did those also, in your testimony and in your estimation, support the allegations of the violations on the property?
Yes, ma'am.
Thank you. And the email and checklist to which you testified, are those a part of your file?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents,
Here you
affidavit
go.
of
I was hearing
posting.
loud bangs when I was changing Kyra's diaper.
That's ice falling from the AC on top of the water heater.
Here you go. I was hearing loud bangs when I was changing Kyra's diaper. Blocks of ice is now falling onto the new water heater from the AC. So you can see it all right here.
Let me start over. I apologize. I lost my train of thought watching the video. The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, photographs, all videos, and the email correspondence with checklist.
All right, those documents are all made part of the record, including the videos. City has proper notice. In this case, even though the respondent is not present at today's hearing, based on the testimony and the evidence, I do find property remains in violation. As cited, I will allow 15 additional days for compliance. After that, daily fines of $200 per day are assessed until compliance is achieved.
Thank you.
I think that's it for the 9 o'clock agenda. Does anybody need to take recess before we, let's see, it's 11:05. Why don't we go off the record and come back at quarter after at 11:15, and we'll pick up with the reduction hearing matters.
Special Magistrate, the other matters are not scheduled till 11:30.
Well, they're not scheduled till 11:30. Okay, well, then we'll be back at 11:30.
Thank you.
Okay. All right, let's go ahead and go back on the record. It's 11:30. This is City of West Palm Beach Code Enforcement Hearing Agenda for July 6, 2022. This is our 11:30 reduction hearing agenda. First of all, if you're going to be offering testimony regarding any of the applications that are on the agenda, your testimony needs to be sworn, so I need to place you under oath. I can place everyone under oath together. If you'll all please stand and raise your right hands, I will swear each of you in together. Thank you. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you. You can all have a seat. If you have any cell phones, please make sure they're silenced so they don't interrupt the hearing. That will be appreciated. Do we have a sign-up sheet for this agenda? I think we do. So when your case is called, please come up to the podium that is to my right. The city will be presenting from the podium to my left. The way we'll handle each case is that I'll get some background information from the city regarding the violation in the case that created the lien in the first place. The city may make a recommendation on what they feel is the appropriate reduction in the case, and then I will hear from you. That'll be your opportunity to tell me about the request for the lien reduction. If you have any documents or other photographs or anything that you want me to consider, that will be the time to produce those. Once I've heard from both sides, I will in all likelihood today enter an order on the request for the lien reduction. So that's generally how we'll proceed. Let's go ahead and get started with the first case.
First case is for number 12-5215 North Flagler Drive, CE 201102003, and also number 13 and 14. Number 13, same address, 5215 North Flagler Drive, CE 210100004, and number 14, 5215 North Flagler, CE 210300246. So numbers 12 through 14.
Good morning.
Good morning.
Just here to say hello, Code Enforcement with the City of West Palm Beach. Case CE 201100203 was cited on November 19th, 2020 for failure to obtain a building permit, clean and sanitary, garbage can placement, yard waste out early, landscape maintenance, and unpaid parking. On January 20th, 2021, the magistrate ordered 30 days or $100 a day to achieve compliance. The property was out of compliance for 227 days, resulting in a lien amount of $22,700. The applicant is who caused the violation. The city is seeking 25%. Case CE 2101004 was cited on December 30th, 2020 for failure to obtain a building permit and required inspections. On March 17, 2021, the magistrate ordered 30 days or $25 a day to achieve compliance. The property was out of compliance for 146 days, resulting in a lien amount of $3,650. Again, city is seeking 25%. Case CE 21030246 was cited on March 10, 2021 for failure to obtain a building permit and required inspections. On June 16, 2021, the magistrate ordered 60 days or $50 a day to achieve compliance. The property was out of compliance for 106 days, resulting in a lien amount of $5,300. City is also seeking 25%.
You have the property appraiser
Oh,
printout?
yes, I do. I'm so sorry. I just want to put a record, the property was just recently sold, but the applicant was the previous owner.
Okay. That's okay. Thank you. Okay, yes, sir. Go ahead and tell me your name and address and then.
Yes, my name is Michael Danchuk. I'm a real estate broker in the Northwood area. I've been coming here to discuss the situation on behalf of the owner, and I have the authority. She had given me the authority to do that. The reason I'm here is it's a very, very unusual situation. I've been a broker for over 20 years, never run into anything like this. I originally sold this home to the past owner, which was John Hoadley, after he broke up with a partner he had in Old Northwood, and we bought this home, and he lived there several years without any problem. Unfortunately, he became ill, started having a major, major drug problem. When he started having that problem, if you're familiar with the Northwood area, there are homeless, vagrant people that live around there, and even though this was on Flagler, they somehow moved in with him. Once they started being in there, he really became a victim in his own home. Police were called over 50 times in the last year just before he passed away. He eventually passed away as a result of a heroin drug overdose, and that's still suspicious as to how it happened and all that. Once I got a call then the next day from his roommate who moved out because she did not feel safe there. She moved out, she called me and said, Mike, I just talked to the sister, please can you go over there, see what's going on. I went over there, found 4 people that were living in there, questionable people, to say the least, and I discussed with them that they really need to leave, that I was going to be representing the owner, and they obviously didn't want to leave. So I spent the next couple of months at my own expense getting people to leave. If you're familiar with evictions and all that, it's very, very difficult. I eventually got them all out except for 2 that said they had a lease, and the lease they said they paid cash, and that became a problem. So I eventually bought them out. And during that time, the owner had a problem with a deck and a fence and obviously debris. These same people had told him they were going to do all the work and pull the permits and do all this kind of stuff. And being the kind of condition he was in, he didn't monitor it. I later found paperwork that he did do. He tried to do it, but he just never finished it. That's why there were no permits pulled for the repairs to the fence and the deck. Eventually, I bought the people out. When I went inside the building then, I actually rented a dump truck, and there was 2 dump trucks full of debris that I had to take out of that home. And this was one of the finer homes in Flagler. I took that out, and the whole thing took me almost a year that I did not charge the client because I felt, because of the situation, and I felt what was going on. We finally were able to fix the home, and we just sold it on May 16th. My client spent over $35,000 just in repairs to try to fix.
Say 55,000? I just didn't hear you.
No, she spent over $35,000.
$35,000.
Just repairing. And then repairs that we're talking about is torn up floors, broken windows. Because of what the activity was going in there, during those 50 reports, there was everything from break-ins, prostitution, drug dealings. Another fatality occurred in there. The police knew this home better than any home on Flagler in the Northwood area, and there was just no way to get it out. I took it upon myself to change the situation, and eventually we changed it. We even bought one of the last people a car just to make him leave that day. And so I bought him a car, and he left, and obviously now it's all been taken care of. So what I'm requesting, because of this very, very unusual situation, is that the city charge us 10%. I understand that violation was occurred, but I'm requesting a 10% reduction on the 3 different charges. And like I said, I've been doing this for over 30 years. I have never seen anything like this. And this man was a victim in his own home. Thank you.
Thank you, sir. Anything else from the city?
No, sir.
All right. So we have three cases. The 2020 case ending in 203 has a lien of $22,700. I will reduce that one just to an even $2,000. Case ending in, the 2021 case ending in 004 has a lien of $3,650. I'll reduce that to an even $300. And 2021 case ending in 246 has a lien of $5,300. I'll reduce that to an even $500. So that's $2,800. How long will it take you to pay that, sir?
I can do it in a couple of days. I'll pay
Put
it
30
myself.
days. Put 30 days on the order.
Just so you know, and I appreciate it, and I actually have paid for all the things, and then the estate would reimburse me, so I'm just gonna pay it myself, and then they'll
Very good.
reimburse me.
All right, thank you.
Thank you.
Sir, here's a copy of the order. Sir? Thank you. Next case, number 8, 1500 Presidential Way, 202, CE 19040306, number 8.
Case CE 190-40306 was cited on April 16, 2019 for failure to renew the rental license and certificate of use. On May 15, 2019, the magistrate ordered 10 days, $100 a day to achieve compliance. The property was out of compliance for 40 days, resulting in a lien amount of $4,000. The applicant is the owner who caused the violation. The city is seeking 25%.
Thank you.
Good morning.
Morning. Go ahead and tell me your name and address, and then you can tell me
Silvia
about the
Aponte,
request.
1500 Presidential Way, apartment 202, West Palm Beach, Florida.
Okay, go ahead.
I'm the property manager of this property, and the previous property management company didn't renew the license. So as soon as I took over this administration, we solved the issue. The license is current.
So the prior management company dropped the ball and let it fall through the cracks. You took
Unfortunately,
over and got
yes.
it back in
Yes.
place?
Mhm.
Okay. The city's recommendation in this case is to reduce the $4,000 lien down to $1,000.
Okay, thank you.
Is there anything else you'd like to tell me?
No, thank you so much.
Anything else from the city?
No, that's it. Thank you.
Okay. This is, as I said, a lien of $4,000. Based on what I've heard, I think I will, in this case, accept the city's recommendation. I will reduce this to $1,000. How long will it take that to get paid?
30 days will be fine.
30 days?
Yes.
30 days. Thank you very much.
Thank you.
Thank you. This case is number 6 and 7 for 700 41st Street, CE 17040379 and CE 180800081.
Erica, what number they were again on the agenda?
Good morning.
Good morning.
It's number 6 and 7?
6 and 7. Oh,
Yep.
thank you.
I didn't know.
I'm sorry.
It's okay.
Case CE 17040379 was cited on April 19, 2017 for inoperative vehicle. On June 21st, 2017, the special magistrate ordered 10 days or $50 a day to comply. The property was out of compliance for 1,675 days, resulting in a lien amount of $83,750. The applicant is the was the owner at the time of the violation. The city is seeking 25%. Case CE 18080081 was cited on August 7, 2018 for safe egress, excessive overgrowth, landscape maintenance, bare landscape, unpaid parking, and outdoor storage. On October 3, 2018, the special magistrate ordered 15 days or $100 a day to comply. The property was out of compliance for 1,202 days, resulting in a lien amount of $120,200. City is also seeking 25% in this case. Special magistrate, I just wanted to point out, as you can see, this property owner has 2 cases in front of you. Both of them took a long period of time to comply, and there weren't really huge violations. They failed to take swift action and and to minimize the harm to the community, the neighborhood. All of this was avoidable. So, yeah. Oh, yeah, I forgot to give you this. I'm sorry.
Thank you. Yes, sir. You can tell me your name and address, then you can tell me about the request for the reduction.
Sure, Daniel Ramirez. My current address is 1281 Rosegate Boulevard in West Palm Beach. The property in question is 700 41st Street. So we've owned the property for a few years. In June of 2016, we moved to North Carolina, my wife and I. 8 months pregnant at the time, my wife was. We moved for a new career opportunity. What we did was fail to change our address. So all correspondence was issued to 242 Lake Monterey Circle, which was our previous address before we moved to North Carolina. So all of the correspondence was sent there. We had no idea that any violation had taken place as a result of the tenants kind of living there and not doing what they're supposed to be doing to maintain and keep it up. So not too long ago, I tried to get a loan, right, and they looked at this property. That's when I found out that there was a lien. So I had no idea up until that point. I reached out to the tenants, and they told me that an inspector had pointed out a few things that had been in violation. As soon as we found out that those things had been in violation, we immediately remedied them. So at this point, every item on the violation list has been corrected and inspected by a city inspector to say that we've rectified the issue. But again, there was no phone call, nothing other than letters to a previous address. We never received any indication. All right, so what I'm asking is reducing the lien amount to something that is affordable, because if those, even at 25%, that's not something that we're able to kind of come up with out of pocket.
Okay. Anything else from the city?
No, sir.
All right. Okay, anything else, sir, that you'd like to tell me?
No, that's
All right.
that's really it. Thank you.
I think I understand what's going on. So we have 2 cases. 2017 case ending in 379 has a current lien of $83,750. And the 2018 case ending in 081 has a lien of $120,200. I will reduce the 2017 case to $3,000, and we'll reduce the $120,000 lien down to $5,000 for a total of $7,000. How long will it take you to pay that?
That's
Massively.
8,000.
Yeah, it's,
3 and 5, so that's a total of 8.
yeah. No, I appreciate it. That's a huge, huge help. We'll be able to take care of that in 30 days.
How many, 30 days?
Yeah, I mean,
30
I've been
days.
here, so that's fine.
All right, here's a copy of your order.
Thank you very much.
Next cases numbers 9 and 10. They're different units, so we might want to call them separately. 401 Village Boulevard, 938 CE 190905551. Are they the same circumstances? Do you want to call them together, or?
Yeah, they're the same owners, just different units.
Okay.
Yeah, let's do them together,
Yeah.
please.
So number 10, 1401 Village Boulevard, 1715 CE 190905552.
Case CE 190905551 was cited September 27, 2019 for failure to obtain a rental license and certificate of use. On December 4, 2019, the property was given an additional 30 days or $200 a day to comply. The property was out of compliance for 750 days, resulting in a lien amount of $150,600. The applicant is the cause of the violation. City is seeking 25%. Case CE 190905552 was cited on September 27, 2019 for failure to obtain a rental license and certificate of use. On December 4, 2019, the property was given an additional 30 days or $200 a day to comply. The property was out of compliance for 753 days, resulting in a lien amount of $150,600. The applicant was the cause of the violation as well. The city is seeking 25%.
Thank you. All right, go ahead and tell me your name and address, sir, and then you can tell me about the request.
Hi, how are you? My name is Andres Abadi. The addresses are 1401 Village Boulevard, 1715 and 938. I'm a real estate agent and property manager. My client had bought the properties with another realtor. He had asked me to start managing them at the beginning of 2020 when apparently the tenant wasn't paying, but again, I couldn't do an eviction and so on. But he had a mailing address that wasn't my address, and it was my mistake. I forgot to change the address. So the violations were sent to the original addresses. I never received them. And I discovered them in 2021, December 2021, because on other properties that I manage, we had a huge case from a master association. So I learned how to check the clerk of courts for violations and liens and stuff like that. So I decided to check all the companies that I manage, and I saw the liens on these properties. I know I dropped the ball on changing the address. it was my mistake, but I didn't do it intentionally. I just never received the letter, and I brought this to show you. I don't know if you can. We apply for all rental licenses to all the apartments that we manage. As soon as we buy them. This apartment, I didn't sell it. So I just took it over, and it was my mistake that I didn't ask, do you have a rental license? And as soon as I got the letter, I contact Monique, which I had contact before. I know Kevin Levine, I know all the inspectors. As soon as I did the inspection, everything passed, everything was in compliance since the first day that I took over the property. So all I'm asking is for a reduction because I never received the letter, and as soon as I saw it, I tried to comply with it.
Okay.
We manage over 200 properties, 100 in West Palm, they all have rental licenses. That's why I brought them here.
All right. Anything else from the city on this one?
No, I'm good. We're good.
All right, so we have two cases, both rental properties, looks like at the same address, different units, same violation. The case numbers were probably heard at the same time because they're sequential, one ending in 551, the other ending in 552. Exact same lien amount, which is $150,600 on each. I'm going to reduce each of these liens to $8,000, so that's a total of $16,000. How long will it take that to get paid? Can you do that in 30 days?
I can pay in 30 days.
30 days.
30 days.
Thank you.
Thank you.
Next cases number 1 through 5 for 1408 9th Street, CE 07071038, CE 09040572, CE 10090038, CE 11080114, and CE 10620667.
Case CE 07071038 was cited on July 27, 2007 for junk abandoned vehicle, a public nuisance, landscape maintenance, sodding the swale, unpaid parking, rental license, and certificate of use violation. On September 28th of 2007, the magistrate ordered 30 days or $50 a day until compliance is achieved. The property was out of compliance for 344 days, resulting in a lien amount of $17,200. The applicant is the cause of the violation. The city is seeking 25%. Case CE 09040572 was cited on April 28, 2009 for trash and debris, garbage and debris overgrowth, vehicle repair, and outdoor storage. On September 23, 2009, the magistrate ordered 60 days or $100 a day until compliance is achieved. The property was out of compliance for 183 days, resulting in a lien amount of $18,300. City is also seeking 25%. Case CE 1009038 was cited on September 2nd, 2010 for trash and debris as a repeat violation, overgrowth, vehicle repair, prohibited vehicles, and outdoor storage. On October 20th, 2010, the magistrate ordered $150 in immediate fines for the repeat violation. The property was out of compliance for 30 days, resulting in a lien amount of $4,500. City is also seeking 25%. Case CE 11080114 was cited on August 10, 2011 for trash and debris, garbage, and debris overgrowth, and as well as a repeat violation. On September 21st, 2011, the magistrate ordered an immediate fine of $50 a day for the 13 days the property was out of compliance, resulting in a lien amount of $650. The city is not seeking a reduction in this case. Case CE 160-20667 was cited February 18, 2016 for clean and sanitary, excessive overgrowth, failure to comply, junk abandoned vehicles, garbage overgrowth, clean up the center of the right-of-way, obstruction of the right-of-way, numbering standards, sodding the swale, and outdoor storage. On April 6, 2016, the magistrate ordered 30 days or $100 a day until compliance is achieved. The property was out of compliance for 871 days, resulting in a lien amount of $87,100. City is also seeking 25% in this case. As you can see, magistrate, the property has a history of not adhering to city codes and has been a nuisance in the neighborhood since early 2000s.
It appears the only reason the 2016 case was not a repeat is because more than 5 years passed since the previous case. Is that right? Okay. Got it.
Yes, and also, even in the case records, even after the 2016 case, there has been instances where they were cited as well, even after running numerous fines.
Did any of those make it to hearing, or did they?
Yes, I believe there was an adjudication on another case. They just complied with the order, but it was an
Okay.
adjudicated case.
All right. All right, yes, sir, go ahead and tell me your name and address, then you can tell me about the request for the reduction.
It's Gary Tejada Senior. It's 1408 9th Street, Palm Beach. I mean, it's a rental. We've had, headache after headache after headache with it. You know, it's not that we don't want to reply, but every time I try to fix it as soon as possible. You know, it's not like we have a lot of extra money around to fix after they're tearing it up. So we try to do my best to keep it up.
All right. Is there anything else from the city on this?
I'd just like to say, Magistrate, just please look at the numerous times that this property was cited. I understand that we may not be able to control our tenants, but to have 1, 2, 3, 4, 5 cases just dealing with just trash, overgrowth, that is a nuisance to the neighborhood, not just the property, the entire neighborhood.
Is there anything else you'd like to tell me, sir?
Say that?
Anything else you'd like to add to the record at this time? Okay, give me a minute here. We got 5 cases to contend with. All right. I try and be as understanding as I can in these cases, but, the city makes a good point. This started in 2007. Next case was in 2009, 2010, 2011, 2016. According to the testimony, there was a case after that. It's just, and it's all the same thing. It's all failure to take care of the property. If you want to be a landlord, you got to be a landlord. You got to pay attention, and you got to take care of the property. And clearly, that's not what's going on here. So, we have the 2007 case ending in 1038 with a lien of $4,500. I'm going to reduce that one to $1,100. We have the case, the 2009 case ending in 572, which has an $18,300 lien. I'll reduce that one to $4,500. We have the 2010 case ending in 038 with a $17,200 lien. I will reduce that one to $4,000. We have the 2011 case, which has a $650 lien. That's a minimal amount. I'm not going to reduce that one. That'll stay at $650. And we have the 2016 case with a $87,100 lien. I will reduce that one to $10,000. I don't know what the total amount is on that, but I will give you, can you pay that in 6 months?
Yes.
6 months.
Yes.
All right, thank you.
All right, thank you.
Is it a copy of your order?
Oh, thank you.
Lastly, number 11 for 2417 Spruce Avenue, CE 200802997.
Case CE 200808297 was cited on August 26, 2020 for failure to secure a building permit, required inspections, certificate of use, and business tax receipt. On October 7, 2020, the special magistrate ordered a finding of fact on code sections 105.1, 110 FBC, and 7 days to comply, or a cease and desist order and a fine of $250 per violation. The property was out of compliance for 629 days, resulting in a lien amount of $157,250. Special magistrate, this case came for a lien reduction prior and failed to pay the settle amount in the time that was allotted. In the previous agreement, the applicant was ordered to pay $2,250. That never happened. Today, the city is seeking 25% of the original fine of $156,000.
So there was a previous request for a lien reduction, and it was reduced to $2,250, and it wasn't paid?
It was not
When
paid.
did that happen?
This was the settlement was on November 18th of 2020.
So that was the end of 2020, so a year and a half ago. Is that the same owner?
Same owner. I think from my understanding today that the owners aren't even here, that they actually have the store, the business owner here.
No. Oh, yeah, yeah.
All right, well.
Yeah, the business owner here to represent this case. From my understanding, this was a major case back in October of 2020, because even after the cease and desist order was given, the store stayed open. One of our former code officer, Patrick, witnessed the business owner putting up open signs and patrons leaving with cups. He even have notes here that he spoke to Lydia and said that they did close for a few days, but then she felt like her and her son felt like the business should be open. So, so a history here of just not listening to orders made by the city. And I think I gave you the.
I have it up here already. Yeah, I sure do. Thanks. Okay, yes, ma'am, go ahead and tell me your name and address, and then you can.
My name is Lydia Stevens. The address of that place is 2417 Spruce Avenue. And I didn't know nothing about that $150,000. For me, it's nothing. I don't know nothing about that. The only thing that I know is about my son rented a place, and we hire a contractor and engineering because we need to do some fixing for he applied over here to do whatever he has to do, fix the bathrooms, and the inspector went and said, you need to do this. So the guys, they were doing whatever they were supposed to do. And then I came after, he says, you can open that. I came to the city, I did it. And I said, we are doing this, whatever the contractor was doing, and we want to open this place. It's a cava bar. And then the lady gave me say, you can open that. And we did it. This is new for me. It's our first business, actually. And then, but after that, we received a letter saying that, we couldn't be open yet. And I came to the city with that. I said, I have this permit, like a little green paper that they gave me to open. I said, we were based on that. So anyway, they said we have to pass other inspections. And then the papers were actually going to the owner and not to us because we are tenants. And then the owner brought a paper saying, oh, you need to close the place because you haven't passed all the inspection. And I said, I didn't know that. So we did, I came to the city again, I spoke, and I said, we were opening because, we received a license, something like that. I think I have that paper that they gave me, so I thought we were supposed to open, that it was okay. And then once they said, the owner gave us a letter like a few months later saying that they received a letter from the owner, from the city, saying that, that we couldn't open, that we had to close until we passed all the inspections. So we felt a little bit like 3 days after we did close. 3 days after we received that letter, we did close. And then we started working again. The place was closed for 2 months. It hurts a lot because the business went down, completely down, But whatever, 150,000, I didn't know nothing like that.
Well, so the owner's not here today, I guess.
Mm-mm.
Why didn't when the lien was reduced to $2,250, why didn't that get paid?
Oh, because we came here, and then they said, I spoke with Mrs. Monique, and I said, we received this thing, and I said, can we apply for this reduction? Because originally, the only one that I knew was 2,250. That's the only thing that I knew from the beginning. So we came one time here, and then we closed everything. They said, if you finish everything, you can, bring back that you finish everything. So we did it. So I went to Mrs. Monique, and I said, look, we closed everything because we were closed for 2 months, but we fixed everything what they needed to be done. And then she said, if you want, I asked her, can I apply again to reduction? Because I always thought it was $2,250. She said, yes, you can apply. So I did apply again. I paid $200, and this is the one that I was waiting for that long. But I never knew it was something higher than that. I don't know how it works.
Has the owner of the property ever been involved with any of this?
He says that in the contract, my son signed a contract, being the first time, he says that all responsibility is under us.
Well, under the law, the owner of the property is the one that gets the lien. So
Yeah,
I
because
don't understand why they didn't pay the $2,250 a year and a half ago.
That's the reason, because they told us if we fix everything, maybe we can ask again. So that's what we did. And let me tell you something, my owner, that the business is not doing well at all.
I don't understand what you're saying, because you wouldn't even be allowed to have a hearing like this unless everything was in compliance. So it's not, so that doesn't make sense.
He gave me this paper. I don't know if you want to see it.
Can I ask a question, Special Magistrate?
Sure.
Are you responsible for paying the lien?
Oh. Everything. We spend so much money in that place, and it's not even ours. The county make us pay $10,500 after we finish everything. And I said, why? He says, because now you're going to get more customers because you did, renovations. I said, but we didn't do nothing outside, zero outside. Only inside was, the bathroom was supposed to be handicapped, and a new water heater, and this and that. And they make us pay $10,500 because we were going to get more customers. They told me that. I mean, we went to close down in time. We don't get no new customers. We're in a lot, like 75% or less customers than from the beginning. I don't know where did they get that $10,500 because we were going to get new customers. And that is not truth. We pay that to the county that is on Jog and Okeechobee.
Okay, thank you for explaining that. Yep.
All right, so after just speaking with counsel, we understand that you're responsible for paying the lien, but we also have to be fair in that there was a ruling made, and we, you know, there has to be some consequence for that. So the city's willing to agree with the original amount times two. Hold on, I'm trying to do the math. It was 2,250.
Okay.
We wouldn't mind settling for the 4,500, being that she is responsible from their whatever the agreement that they have, that she would have to pay for it. But we still feel like because there was an agreement and prior that wasn't fulfilled.
Okay.
I swear I didn't know
Ma'am, is there anything else you'd like to tell me about this?
that. Not really, I don't know what to do.
Okay, well, right now, the property is in compliance, yes?
Oh, yes, it
There's
is.
nothing else that needs to be done other than to pay.
We did everything. We
Okay.
keep the place very nice and clean.
So we have this is a 2020 case. The lien is $156,000. I'm gonna reduce it today to $4,000, okay? I don't know, how much time do you need to pay that? I can give you.
6 months.
6 months? I'll give you 6 months to pay that, but you need to pay it within the 6 months, or it's gonna go back to the $150,000 again. So there shouldn't be anything else you need to do other than, there's nothing else you should have to show anybody other than a check for $4,000 within the next 6 months. There shouldn't be any other hoops to jump through that I'm aware of. It just needs to be paid, and that'll make this go away. But, I will do $4,000 in 6 months.
I didn't know I think it's not right because, you know, Your Honor, I didn't know about those 20, I mean, I swear I was told that we can have a chance to claim the 20, because originally I thought it was 2250. That's what we were told. And then that's what I went to Monique.
It didn't get paid.
Yeah, but Monique told me that I can.
I've entered my order in this case. I don't,
Aw.
I will sign that order, okay?
Thank you.
And that completes the agenda.
I think that concludes the agenda. All right, it's a little after, 12:15, and we stand adjourned.